I'm in
All
California.
right. Good afternoon, and thanks so much for tuning in, everyone, to this important event today. Today's conversation is part of our ongoing series, Holding Court Justice Conversations with AFJ. This series features leading activists, authors, scholars, and attorneys discussing current political and social justice issues. My name is Rachel Rossi, and I'm the president of Alliance for Justice, an organization that collaborates with nearly 140 members who are committed to building power, transforming courts, and securing justice for all. We're actually lucky because our speakers today come from actually two of our valued member organizations, the National Association of Councils on Developmental Disabilities and the Bazelon Center for Mental Health Law. Today's event, Holding Court, Expanding Disability Rights and Defending the ADA 35 years later, is an opportunity to reflect on the 35th anniversary of the Americans with Disabilities Act and to think about what we have to do to continue expanding rights and accessibility. The discussion today will also focus on the impact that state and federal legislation has had on people with disabilities, court decisions that have expanded or hindered disability rights, and the state of disability rights under the second Trump administration. We have two wonderful speakers joining us today who I am thrilled to introduce to you. First, from the National Association of Councils on Developmental Disabilities, we have Erin Prangley, who serves as their Director of Public Policy. Erin has more than 2 decades of experience in public policy and legislative affairs. Prior to joining NACDD in 2017, Erin worked in government relations at the American Association of University Women and for various members in the U.S. House of Representatives. Erin, we are so glad that you could join us today. Also joining us today is Jennifer Mathis, the Deputy Director of the Bazelon Center for Mental Health Law. Jennifer previously worked in the U.S. Justice Department's Civil Rights Division, reviewing and leading the work of the Disability Rights Section and the Special Litigation Section's disability work. I was privileged to serve alongside Jennifer Mathis in the Justice Department previously, so I know of her deep expertise on these issues. Jennifer has also litigated community integration cases and helped craft language for and secure passage of the ADA Amendments Act. Jennifer, we're so thrilled that you get to join us today. For our audience, later in the discussion, there will be an opportunity for you to ask questions. Please submit your questions in the comment box on whatever platform that you are watching. And also please note that AFJ staff members will be monitoring the comments, and any comments that are not in line with our mission or are discriminatory may be deleted. Additionally, if you would like to have live captioning for this discussion, please tune in on the Alliance for Justice LinkedIn page. We will drop a link to that stream in the chat right now. All right, so let's get started. I want to start by launching in to talk a little bit about the history and why we are here. One moment. All right, so sorry, just a moment. I have too many tabs up right now. All right, so we are here today because the Americans with Disabilities Act, a landmark civil rights law that prohibits discrimination against people with disabilities, was passed 35 years ago and 1 month to today's date. Sorry, one moment. And so if our speakers could just start by sort of giving us a little bit of that history, what led up to the passage of the ADA, and what advocates had to do to fight for and to secure that landmark legislation being signed into law. Go ahead, either one of you can jump in on that one.
So thank you, Rachel. Jennifer, I'm going to jump in because I'm going to go way back. I'm going to go in the way back machine. As Rachel mentioned, I work for the National Association of Councils on Developmental Disabilities, and the councils were created through a piece of federal legislation called the Developmental Disabilities Assistance and Bill of Rights Act. And you're like, oh, Erin, what does that have to do with the ADA? Well, the Americans with Disability Act, as you know, grew out of the civil rights movement. In fact, it's one of the most exciting things I think about working in this field is that we are cutting edge civil rights. And I experience that every day. And when I look at the ADA, I don't think about 1990 necessarily. I think about 1963. And the reason I think about 1963 is because that was when we had the first type of legislation that acknowledged persons with developmental and intellectual disabilities. And that was passed and would later become something that we now know as the Developmental Disabilities Assistance and Bill of Rights Act. And that's the legislation started by the Kennedy family because of its close ties to the issue. For those of you who don't know, John Kennedy had a cousin, Rosemary, who actually had an intellectual disability, and that family has always been very involved in the intellectual disability movement. And his family helped start legislation that in 1970 was reauthorized as the Developmental Disabilities Act, which established the Developmental Disabilities Councils. Governors appoint council members in all 50 states and territories, the University Centers of Excellence, and the Protection and Advocacy Systems. Now, these entities, which have been around for decades before the ADA, focused on leadership development, community integration, creating policies and legal advocacy to build an infrastructure in the states that would support creating legal rights for individuals that they can enforce in the court. So the DD Act created these councils, set up a system of lawyers, which you may know as Disability Rights Maryland or Disability Rights California. And those folks started working before the ADA to educate policymakers and the legal system about existing laws that were civil rights laws that were expanded to people with disabilities. And so I kind of see that as the start of something pretty spectacular, which of course then we had the Rehabilitation Act of 1973. And Jennifer, you could take it over from there. But I just wanted to start by saying that the Disability Act is the disability rights, and the ADA is a civil rights law. It's a natural extension of what was happening in those tumultuous 60s and 70s with women's rights and racial justice and all of the things that make America when we think about that incredible civil rights era. And and we were there as people with disabilities, working through the Developmental Disability Act and establishing and educating people on what disability looked like and how people could use existing infrastructures in the state legislatures to enforce and improve on those civil rights. And I'll leave it to Jennifer to take it over with the Rehab Act.
Sure. And I think I might have even started with the 1940s and Jacobus Tenbrook and the White Cane laws and stuff. So we go way back. But I think the Rehab Act is an important part of the history that led to the ADA. The Rehab Act was passed in 1973 and was primarily about funding employment, supports and services, vocational rehabilitation, et cetera. And one of the most important things, one of the galvanizing moments that led to really the movement developing in the way that it did, which later led to its working together to pass the ADA, was the 504 sit-ins or protests. And so 1973, Section 504 of the Rehab Act, which says that essentially, in a nutshell, entities that receive federal financial assistance can't discriminate based on disability. um, that is like a paragraph or two in the Rehabilitation Act, and there's supposed to be regulations that Congress directs, and that's fine. And then nothing happens. And well, I shouldn't say nothing happens. The federal government, in fact, HEW, the Health, Education, and Welfare Department, at that time before it got split up into HHS and Ed, HEW had developed these regulations, had gone through a significant process, and these regulations were really important for Section 504 to give it meat, to give it meaning and meat on the bones, because Section 504 didn't say a whole lot in the statute, and Congress had really left it to the agencies to flesh out what is disability discrimination, what does that mean, what does this law require. And so people with disabilities were obviously eagerly awaiting these regulations, and they weren't coming, and they weren't coming. And so at some point in 1977, after 4 years had gone by since the passage of the Rehab Act, the disability community decided that it was time to do something else. And we saw some direct action. We saw the longest occupation of a federal building in history. There were protests all over the country in HEW offices. And this one sit-in of the HEW building in San Francisco, which was led by Judy Heumann, which you can see, by the way, a version of in, if you Google Drunk History 504, it's actually pretty entertaining, but kind of pretty accurate as well. Judy used to say it was pretty accurate. So you had that sit-in happen for something like 28 days. That sparked a lot of conversations, and a lot of, it led to congressional hearings. It led to eventually Joseph Califano, Secretary of HEW, finally signing regulations and promulgating regulations that gave life to Section 504. And those regulations became really the foundation for what is in the ADA. If you look at what Congress was looking at when they passed the ADA all over the legislative history, you can see the history of what happened under Section 504. And mainly, the ADA was about taking the experience under Section 504 and extending it to a much broader set of entities. So not just recipients of federal funds, and then 504 was later amended to also include federal executive branch agencies, but the ADA applied beyond that, applied to state and local government entities, it applied to private employers, it applied to public accommodations, which are things like stores and hotels and doctors' offices, social services establishments, private schools, all kinds of privately operated, open to the public accommodations. And so really took the mandate, the anti-discrimination mandate, and made it much more widely available. So that's kind of how we got to the ADA. I would just say one more quick thing. The way I think about this sometimes with the history and sort of the groups of people who were key in different ways is that in Berkeley, you had the birth of the independent living movement, Ed Roberts, and independent living, a whole philosophy and kind of service system stuff coming out of Berkeley. In Denver, you had direct action and you had ADAPT coming out, putting their bodies in the streets because they couldn't get accessible transportation, and beginnings of that movement. I don't remember even what ADAPT stood for originally. Americans Disabled for Accessible Public Transportation, I think. And so now they're much broader, but back then, that's what it is. So you had the independent living movement in Berkeley, you had Denver and the direct action, transportation, accessibility. And then in Pennsylvania, you had the lawyers and lots of important early litigation, Pennhurst and Youngberg versus Romeo, lots of early cases where important stuff was happening out of Pennsylvania, later Helen L., which became sort of Olmsted before there was Olmsted. So that's how I think of disability history in clumps. Anyway, I will turn it back over to Rachel.
Oh, I love it that you took us all the way back, because it really shows that this is a movement that is really playing the long game to achieve equity and access. So I'm very curious. You took us as far back as the 40s, and you sort of talked through all of the different sort of pieces of the conversation, the activists involved, the federal government involved, the regulations, the legislation. And I'm curious, just sort of fast forwarding to where we are today. How would you say that the disability rights movement has evolved over time compared to 35 years ago, 40, 50 years ago? What were the priorities, would you say, then? And what are the priorities today? And how has activism by and for people with disabilities evolved?
Thanks, Rachel. And I'd just like to say, the famous line from the signing of the 1990 Americans with Disabilities Act was when President Bush, Republican president, standing at I hope it was the Rose Garden, but it might have been somewhere else. But it was beautiful, beautiful signing. Everyone was there. When he signed the legislation and said, "Let the shameful wall of exclusion come tumbling down." And I think that I look back at that and I'm like, oh, what a great speechwriter. But as you can tell, this wall of exclusion had chinks in it. We had been chipping away at that wall for a very, very long time. And people, as Jennifer said, had been literally putting their lives on the line for a very, very long time. And to think that signing this one piece of legislation would just bring it down, and now we've achieved, equality, and it's 1990 and we're so enlightened and everything. Now that government has spoken, because this is a very broad civil rights bill, government has spoken in the areas of education and employment, and as I said, very much modeled after 1963 Civil Rights Act legislation. Now it's done, right? We're good, we're golden. There's no more discrimination. It's just not allowed anymore. I think, that served a purpose. It served a very important purpose. It's definitely something to celebrate. But as those of us who work in the area know, that was just the beginning. And the legislation that we talked about before, the 504, the Rehab Act, the Developmental Disabilities Act, which funds a lot of the lawyers that are doing the civil rights work that we're talking about. Not all of it. ACLU, thank God for them. And Jennifer's group, Bazelon, thank God for them. But, all of these other laws still exist for a reason. We work together to make sure that the goals and the aspirations of this beautiful society where the wall comes tumbling down, it can be a reality. And now that we're looking decades since then, I think it is a real question. There's no question that these laws have been applied in ways that have benefited the lives of people innumerably. I mean, we didn't even talk about the Individuals with Disabilities and Education Act, which also was part of this movement. But civil rights is tricky. Civil rights is hard, and the way that we are looking at that legislation now, we can't forget about the importance of the Rehab Act, because the ADA did not, for example, fund any of its equality measures. Those are funded through appropriations. Those are funded through the, what administration does with the departments of civil rights in each of its agencies. So we have to look at the ADA not only in terms of its aspirational goals, but there's also federal statutes and laws that can help us get to what we think the ADA was trying to say, which is a free and open society that's inclusive of everyone and provides community opportunities so people no longer have to be forced into the shadows and live in institutions.
So, yeah, I mean, you raise a point. I think people need to understand, of course, laws are not self-executing, right? It's not like you pass a law and then everything gets fixed the next day or even the next year or the next decade or whenever. But we have to use the laws, right? And that's part of it. It's a lot. It is complicated. There's a lot of barriers in society. We've come an enormous way. I think the ADA has made an absolutely enormous difference in people's lives, and in so many ways it's hard to encapsulate. People have different expectations now, people with disabilities, about what their lives should look like than they did before the ADA. Yes, there are many, many problems, and we have a very long way to go. But some of that is, we don't necessarily need new laws. We just need to actually use the ADA. And it's sometimes challenging to do that. The courts have made it more and more difficult in many ways to bring the same kinds of cases that maybe 10, 20 years before you could have brought, because there are all kinds of other barriers, threshold issues, etc. So there is all of that. But I think in some ways, to me, the genius of the ADA is that it is so broadly written, as civil rights laws typically are, to cover things that Congress might not have anticipated back then. So, I mean, we are always using it in new ways as new issues come up. And some of that is things that, Congress just wasn't thinking about because we didn't have mobile apps back then. And, website accessibility wasn't really a thing that people talked about or understood, or most people didn't use websites back then. But those things now obviously are critically important, and one can't get through a day without using a website or a mobile app. And so suddenly the accessibility of them is an enormous problem for people with disabilities, who increasingly start getting left behind. We have new problems that didn't exist at the time of the ADA. So the law is flexible. The law can be used in these new ways. Other things that we are always thinking about, even if they existed at the time that Congress passed the ADA, but they weren't thinking of them. Emergency response systems, we're thinking of that now. Why do emergency response systems rely on police as the default responder when the person has a mental health emergency call, as opposed to any other health emergency, and where they would send an ambulance or a medic, right? And so that just wasn't something that people were thinking about at the time of the ADA, but now people are using the ADA in new ways. So I think our ultimate goals are the same. I think the ADA has 4 main goals, and for the most part, those goals, I think, still hold: equal opportunity, full participation in society, independent living, economic self-sufficiency. It's just that we're always thinking about and identifying new ways and new applications, new things that need to be done, new barriers that we've discovered, new things that we need to do using the ADA to try to address those goals. So it looks different than it used to, but I think we're after the same general set of core issues.
That's so helpful. And I want to sort of zero in on something you raised, Jennifer, just the role of the courts in all of this, as we've seen the movement continue over the years. You mentioned some court decisions that made it more difficult to gain protection under the ADA. We know that Congress passed the ADA Amendments Act in 2008 to try to get to sort of ameliorate some of those concerns. And then, of course, the 1999 Olmstead case, which I know you know very intimately. Just curious for both of you, your perspectives on how have the courts, the Supreme Court and other courts, played into this, the movement over the years and where we are today.
I know Jennifer is really the one who should be speaking to this, but I will say that I almost speak in hushed tones when I talk about the Supreme Court and the importance of Olmstead, because as we know, the court is constantly changing, and this current court doesn't really think about stare decisis the way that I was taught to think of stare decisis. But I will let Jennifer talk, but I will say that Olmstead remains a real strong point when we are talking about the connection between community living and rights, right? And how we all have a shared concept of what does it mean to be a full citizen in the society. Namely, nobody should be forced to live in an institutional setting against their will. That's just, I mean, Jennifer can tell you the legal, but the plain language is nobody, because of their disability, should be forced to live in an institutional setting where they can't control, when they eat, when they sleep, who can come over, who can provide care for them, whether they can put a poster up in their room, whether they can have a phone or a computer to communicate with the outside world, whether they can leave. These are all things that still happen in our world. And when Lois and
Elaine,
when Lois and Elaine, brought those issues up, many people were sincerely ignorant that such a thing existed in our country, that people really were, captive because of their disability in situations that none of us would consider, acceptable. So thank God for Olmstead. Thank God for the courts. But as I said, I kind of talk about it in hushed voices because I think the lawyers out there litigating are going to tell you, as much as we've pushed Olmstead, there are still several attacks in the courts and also through legislation that we need to continue to push.
Yeah, so you took me back to ADA amendments too. I spent a lot of months of my life with that. Chai Feldblum used to say she didn't have kids, she had laws, and the ADA was her first kid. And when the ADA came home from college, essentially unrecognizable, with purple hair and a nose ring and stuff, Chai decided, she needed to have a second kid. And so that was the ADA Amendments Act. But anyway, the ADA Amendments Act, we spent a lot of time on, ultimately negotiated with the business community to come up with a compromise proposal that was introduced in Congress. The Congress worked with it and made it their own, obviously, but it became the ADA Amendments Act. And we needed to do that because we had reached a point where the courts had so misconstrued the ADA as to make it meaningless for large segments of the disability community. That's why I said, my law came back unrecognizable. One of the things they had done was they had said that mitigating measures, when you determine who has a disability, mitigating measures, things like medication or prostheses or therapies or something that you use to control the limitations that your disability may create, that you have to count those mitigating measures when you're looking at whether a person has a disability, which was completely the opposite of what Congress had said in committee report after committee report. And of course, the Supreme Court did not seem interested in that legislative history, even though it was so crystal clear. And there was a very good reason for not considering mitigating measures when you were determining who had a disability. But they said, nope, if a person has diabetes and the person is taking insulin to control the impact of their diabetes, that person may not have a disability. If that person is having issues at work and that person is not getting a reasonable accommodation, if we think that with their insulin they're fine and they would not have an impairment that would rise to the level of a disability, they're not disabled. At some point, people with epilepsy, people with diabetes, people with all types of disabilities, but particularly those two, a lot of people with psychiatric disabilities were getting found over and over again not to be disabled under the ADA. Could they be fired because of their disability? Yes, we used to say they're disabled enough to be fired, but not disabled enough to sue. It was a weird situation. So we fixed that. We fixed a bunch of things in the ADA Amendments Act. We fixed the mitigating measures issue. We fixed the Supreme Court statement a couple of years after those cases where it had said that, where they said, even though it's a civil rights law, which usually means it should be broadly interpreted, they said, oh, it should be narrowly interpreted strictly to create a demanding standard. And so after that, lots more decisions where people weren't covered. And so fix that. So it now says it shall be broadly construed to the maximum extent permitted by the terms of the law. We fixed other things when people had disabilities that were intermittent, where you might have an impairment, but it would come and go, like a seizure. You're not going to be having a seizure 24/7 in most cases, hopefully. And so they were like, oh, you spend a lot of your time not having a seizure. You're fine during the rest of that time. Or with a psychiatric disability, well, you may have these episodes, but they're short, and the most of your life you're not in them. And so therefore, we don't think you have a disability protected by the ADA. So all of that got fixed by this ADA Amendments Act. And we said that you consider an impairment that is episodic or in remission, you consider it when it's in its active state. And so there was that. There were a bunch of other things. We clarified major life activities because they were parsing apart what was a significantly major activity. And so we just clarified that major life activities also included body systems, major bodily functions. The endocrine system is a major life activity, the operation of the endocrine system, the operation of normal cell growth. So for folks with cancer, this was a very significant thing. We clarified reading and concentrating and thinking and all the things that I think are important for demonstrating mental health disabilities protected by the ADA are covered. And so, it was really an enormous change. And as a result, after the Amendments Act was passed, it didn't end difficulties with using the ADA, but it ended that set of difficulties, which was really keeping people with disabilities from even getting their claims heard. They were not really much past the courthouse door because they just couldn't get to whether there was discrimination or not. And so that was a very big deal. Could we do that today? Not probably in the current environment. But it was important to do. Courts are great and are, a very important mechanism to enforce the law and give them meaning. At the same time, courts create challenges. We try to be as clear as we can in statutes. Doesn't always work that way. All the things that, are canons of statutory construction when Congress passes a law somehow later on end up out the window when other courts are reviewing them. So it is complicated with the Supreme Court's decisions about agency deference now because there are a lot of regulations that have been important to the ADA. I think we can manage regardless, but it just changes the whole analysis. It changes the way courts look at this, and that's always changing. And so that has been certainly a struggle. But yes, the court in Olmsted, that was one of the most significant decisions that we've had for people with disabilities. It's sort of a liberation decision in a sense, saying that needlessly institutionalizing people with disabilities is a form of discrimination, and that you need to administer, public entities need to administer their services to people with disabilities in the most integrated setting appropriate. That has been an enormous shift. It has really changed what service systems look like. It has changed how service systems think about people with disabilities. Many people, many tens and tens of thousands of folks have gotten the chance to move out of institutions because of Olmsted litigation, avoid admission into institutions for that reason. Many others, wholly apart from litigation, have benefited from that because of voluntary compliance efforts, community service systems trying to do some things right and expanding community services. It is never, nobody's fully complying. It is still, there's a very long way to go. It is a difficult environment for people with disabilities, it is now going to be far worse, because a lot of that progress that was made will be undermined by what Congress has just done with this One Big Beautiful Bill Act, and ripping into Medicaid, which provides all the supports, of course, for people with disabilities to live and thrive in the community. And so we are always in one struggle or another. We are always, when we do well with the courts, that's good. But then sometimes Congress does something or state legislatures do something to make it very difficult, like Congress has just done with Medicaid, right? And sometimes when Congress does something, we need to turn to the courts because that's our best option. And so I think the lesson learned is we go wherever we need to go. We take every opportunity available. We don't give up. And there is always another avenue for us. And we always need to be creative and thinking about what the best strategies are. Sometimes when there are attacks on Medicaid, we end up doing more ADA work. Sometimes when there are attacks on the ADA, we end up focusing more on Medicaid where we can. So really just need to think about things as broadly as we can and always find the opportunities that may be there.
I love that. And can I just say it's inspiring what you're both talking about over time with the movement for disability rights, just because you're always thinking about the impact, whether it's laws, regulations, policies. How do we make sure it's having the right impact? And to me, that means we're staying closely aligned with the community, and understanding what isn't working and what more needs to be done. So I want to zero in on what one of the areas you sort of raised, Jennifer, just talking about the moment that we're in right now and the environment that we're in. We are 8 months into President Trump's second term. You mentioned the big, beautiful bill that we know impacted Medicaid. Also, an executive order last month ending crime and disorder on America's streets, which promotes involuntary commitment. We also saw a SCOTUS decision just a couple of months ago in Stanley versus City of Florida, just shutting down efforts by a retired Florida firefighter to sue under the ADA. Just curious if you could kind of dive into more this moment, where we are right now, what we're seeing, and what this requires of us and the disability rights movement today.
So I was going to let Erin start with all these, but if you want me to start, it's up to you.
All right, I'll start because I feel very strongly about this. I just don't want to take all the oxygen. Yeah, I mean, this is what Jennifer said about different pathways. We have to explore different pathways because there is no doubt that the federal avenues for enforcing civil rights are very narrow right now, to say the least. And a couple of other executive orders we didn't mention, of course, is the attack on diversity and equity and inclusion. They include the I in there too. But, we are seeing, in terms of our advocacy, we're seeing a lot of changes being made by the executive. Whether those changes are legal or not, that's something that the courts are going to have to really work about. And you talked about the ending crime and disorder on American streets. This is a extremely ableist executive order that will impact people who are homeless disproportionately, people with disabilities in the broad sense of the term, people with mental illness. And it encourages forced institutionalization, which is the antithesis of what the Americans with Disabilities Act stood for, and with the integration mandate in there, and what the Supreme Court Olmstead stood for, which is, that mandates integration of people with disabilities into society. So, the executive orders are coming fast and swift, and the president is acting on them. It will have a disproportionate impact on people with disabilities that will be litigated and is being litigated in the courts. A lot of the problems with the executive orders, though, is before they can be litigated, we have to show the harm. So Bazelon Center and other folks are doing an excellent job collecting the stories from people that are showing the immediate impacts of this. The states themselves are going to be facing a lot of pressure because the funding for civil rights enforcement at the federal level has the president's budget decimates the lawyers and the civil rights enforcement through the agencies. And so the states will be called on to take on more and more of the protection and enforcement of their state civil rights laws, as we will not see as much involvement with the wonderful DOJ as we had seen before with Olmstead settlements and things like that. I think we'll see the states and the state attorneys general taking a much bigger role in pursuing enforcement of these federal rights, but also the state rights laws. And I'll turn it back over to Jennifer.
Yeah, so this is the depressing part of the webinar, but it is hard to overstate the damage that is being done right now in so many different ways. And I think sometimes people have said over time, well, when there's administrations that are more hostile to civil rights, people with disabilities often don't do as badly sometimes. I think right now it's hard to see what's happening as anything other than bad for people with disabilities. And, Erin talked about some of the ways, and certainly the executive order. One of the things that I think may come out of it is it's so obviously, I'm talking about the one on civil commitment and homelessness. It's so obviously backward. It's so obviously promoting solutions that are not going to work because we've done them before, but also, it's not just not going to work. It's going to create more homelessness. The very point of the order was theoretically to end homelessness, and with the idea that would therefore end crime, which is a whole other set of unfounded presumptions. But taking away, defunding housing subsidies that support housing first, housing which works, which we know from decades of evidence, studies, people's lives and experiences, that it works when you actually don't take the folks who are most in need and leave them on the street because they aren't going to comply with all the rules or treatment regimens, and so you just abandon them. We know that doesn't work. That's exactly where we're heading back to with this executive order. I think there are pieces of it that people can use to try to mitigate the damage as much as possible, and we're all hopeful about that. We don't know exactly what HUD and HHS and DOJ will do with it yet. But certainly, if they're going to do the things that they're talking about doing in the executive order, that is not going to be a success that anybody can point to. So, one would hope that they would sort of die of their own weight at some point when, they don't pan out to have the results that are touted. So there's that. With the budget reconciliation bill, it's just hard to know how we get out of that one okay, because it is just going to be so devastating to so many people with disabilities who are going to fall off the rolls, not because they're not working with work requirements, but because they're not reporting, or not because they're not exempt, but because they're not keeping up with all these reporting requirements, and maybe they don't have access to a computer and they're trying to call by phone and nobody's answering the phone, and they're trapped in plenty of red tape, or they understood that they needed to do it this month but not the next month, and we saw all of that in the past. And so that, together with the more frequent eligibility redeterminations that will happen, which all seem designed to get people off of the rolls of Medicaid, again, seems hard to see how this is seen as helping anybody. It's not going to get people work. It didn't before. It's not going to now. And so I think one of the saving graces is that states will have to do everything they can, even though they will be hurting themselves because of the dramatic budget shortfalls they'll be facing because of what Congress has done. But I think most of them are not going to want to lose people off the Medicaid rolls because they're getting a lot of federal dollars for each of those people. And so there's a lot of cost that's going to fall on the states as well as state and local governments if they lose all these folks off the Medicaid rolls in their states. So one would hope that we can work with them to some extent to mitigate some of that damage, but it is unfathomable at this point. And it is a dark time, and I don't have any I wish I had the magic bullets for how we do okay at this time, but I think we are all trying every way we can, and we are exploring legal challenges where we can to try to address things. We are exploring advocacy work where we can to try to make things better in other ways. We are exploring creative solutions with how one might figure out ways to preserve some of the housing, for example, that we think might go away under this executive order, and how to frame things. I won't say too much on here about that, but there are ways that people can be helpful.
And Rachel, I just want to say something that Jennifer brought up, and I want to ask everyone to really think about this, because we've been working during the Biden administration and even back to the Obama administration, we were working on expanding rights. What we're doing right now is we are looking at defending rights. And so I know we all need to take a minute to pause and look at the strategies that we're using and explore different avenues for strategies. So many of us, for example, may have been working on, I love the LaTonya Reeves Act, which is an independent living focused act that would take the Olmstead decision in the courts and force Congress to vote on it and make sure that we all have this, in statute, that people should not be institutionalized. They should have the least restricted settings. That legislation could have been your passion for the last 4 years, 5 years. Right now, we are dealing with, we are dealing with resources that are rolling back. We are dealing with challenges, rollbacks to civil rights protections through these executive orders, expanded civil commitments through this new executive order, and less money going to home community-based services because of Medicaid cuts. We are dealing with the elimination of lawyers and civil rights enforcement at every single agency, including, don't even get me started on the Department of Education. I know you want to talk about IDEA. We want to talk about it too. The Trump administration wants to get rid of it and send all of our kids to, to private and charter school vouchers. So we have got to really think about strategies and work together and not get frustrated, that maybe we aren't spending as much time on things that we spent on in the past, because in the past we were pushing for more. Now we are trying to hold on to what we've got. And that is a really difficult position for advocates to be in. It's something that I struggle with all the time. But we need to work with state legislators and Republicans and state legislators, for example. We are looking for champions, not parties, individuals who can step in and make a real difference and stop the harm that is coming at you. And it's coming at you fast, and you might not realize it this year, but definitely after the midterms, we're going to see some real pain in our community unless we can find those champions to protect the rights that we've earned.
And that is true. I think that raises for me one silver lining, if there is any silver lining that can be said to come out of all the darkness of the current moment, which is that I have seen there's a lot more alignment among a lot of groups in the disability world, in other worlds, in the disability and homelessness world, and substance use world, and civil rights world, and stuff, where a lot of people were busy fighting about different pieces within the advocacy of this road versus that road. And the way things have gone, some things have been so extreme that now I feel like it's interesting to see everybody aligned in a way that I haven't seen for years, because we all are understanding we're in this together, because we all think that some of these things are really, really bad. And so I do think that if there is anything positive to be said about it, I do think there is some strength in that unity and alignment.
You know, I love that, even though we're covering the darkness of the moment. I think both of you are lifting up strategies and silver linings, but also encouraging us to fight back in this moment. So we're running close on time, but so what I'm going to do is throw out one audience question, and then for both of you, would love for you to just sort of wrap up with final thoughts on what can individuals, what can advocates do in this moment, whether it be looking up and supporting your organizations and the work you're doing, or other steps that they can be doing to support disability access, disability rights, and disability justice. So quick audience question, and then please closing thoughts from both of you. So one of our audience members asked, can you touch on education issues and what we can expect as far as support from the Office for Civil Rights and the Office of Special Education Programs, and what can be expected regarding learning disabilities and hidden disabilities? So feel free to touch on that, and then give us your kind of final thoughts and your call to action, if you will.
I'm going to speak broadly because Jennifer can answer this question much better than me, but broadly, we will not see someone come out and say, we don't like educating children with disabilities, so we're going to get rid of these programs. They're not going to say that. Politically, that's not going to work for them. Instead, what the federal government will do is lay off lawyers, eliminate departments, and stop funding education. Now, education, of course, is in the domain of states. It's not in our Constitution. It's the states that determine education policy. However, as the federal government pulls out of this space and allows the state to do things like vouchers and other things, we will see a lot more activism at the state level. Many states have mirrored the IDEA with similar civil rights laws in their own states, some of them in their own state constitutions. We've got to work at the local level. We've got to get involved with the school boards and just tell them, no, this is not acceptable. We've got to get involved with the superintendents. We've got to get involved with the state legislators and say, whatever's happening in Washington, D.C., we cannot, as a state, we will not, stand for the dismissal of, special education teachers, or we will not stand for, separating our children based on disability. This will not happen. And I do think that would be my strong urging to you. The feds will pretend that they care about people with disabilities. Meanwhile, they are slashing budgets and they are firing people like you will not believe. And they are rejiggering things that will be extremely detrimental to the states. And ultimately, it's the states that will have to deal with this problem.
Yeah, so I do think, Erin, you said a lot about education, actually, even though you said you were going to leave it to me. So I don't have that much to add, but I do think that's right. There have been mixed results in the courts on these various pieces of litigation around what's happening at the Department of Education. There's been a couple of, maybe 3 now, lawsuits that are focused on the Civil Rights Office particularly, and what's happened since they shut down 7 of the field offices for OCR. And that office has been playing such a critical role in addressing the discrimination that happens, the needs of kids with disabilities, along with other types of discrimination as well, obviously, and cannot do it with the kind of staffing that exists. And whatever will happen, of course, if and when they succeed, well, I should say if they succeed in shutting down the Department of Education altogether, or will it go to the Justice Department, which is not going to be resourced to handle all of that. And so, yes, it is an enormous problem. There's other education proposed cuts and reorganizations and lots of things. One bright light spot that happened was the Senate Appropriations Committee passed an appropriations bill out of the committee that rejects a lot of the cuts that were proposed and a lot of the reorganization, elimination, et cetera. So, I mean, that's just the beginning. And we all know we need to be very loud, and we need to be heard, and we need to be savvy, and we need to be working together to try to address that and to try to make people get it, or to make people feel shamed about it. I'll take either one, as long as they vote no. But we have our work cut out for us there, education and otherwise, with all of this. And so, what people can be doing now, I would say, practically speaking, number one is, well, we all need to stay together. We all need to, we don't need to duplicate efforts. It is helpful. I feel like there is so much going on that certain things that I would normally do, I've put aside and said, I trust the people over here doing that. It might not be exactly what I would say or do, but it is close enough. And I'm going to focus on these 15 things because I can't focus on 570. So I'm going to do these things, and everybody should do the things they can manage, right? And to pick their core issues, to coordinate with everybody else. But we have to be smart about dividing efforts, because we can't do it all. And that doesn't mean we should do nothing or flame out. And it's important that we all stay in this fight. So I think working together, just staying connected with as many of the networks as possible. We all feel like there's too many meetings all the time, but at least you can stay on top of people's listservs and people's email chains and all of that, and just go to enough meetings that you need to coordinate with everybody else and make sure that somebody is covering and leading each piece of the things that need to be done.
Love that. And I'll just add in the one of the through lines that I loved from everything that you both said today, just thinking about centering the voices also of the community, people who have disabilities, making sure they're at the forefront as we continue this fight. I don't know about you all, but I could stay on for another hour to talk with these fantastic experts, but we are at time. Thank you, Jennifer, and thank you, Erin. It really was a treat to join you today and to reflect on 35 years of the ADA. We know that the fight for disability rights and justice is far from over. And I will take to heart your call to action. We believe this requires a collective effort, and we all have to be in this together. To our audience, if you want to get engaged, please visit the websites and social media profiles of the National Association of Councils on Developmental Disabilities and the Bazelon Center for Mental Health Law, and keep up to date and learn about what these great organizations are doing. We also hope you will follow the Alliance for Justice on social media to stay up to date on future events like this. And also, in fact, AFJ, along with AFJ Action Campaign, will be hosting our 4th annual in-person holding court Supreme Court term preview on Tuesday, September 9th. At the True Reformer Building in Washington, D.C. We're going to have a panel of experts talking about the upcoming cases on the 2025-2026 docket. And we're thrilled to have Congresswoman Mary Gay Scanlon giving closing remarks. So please see the link in the chat and register and see us there. We really appreciate your participation today. We look forward to your continued engagement in future discussions. Thanks everyone for tuning in. We can't wait to see you next time.